going to introduce myself. Good afternoon, everyone. My name is Monica Krup, and I am co-editor-in-chief of the Race and the Law Review.
And hi, everyone. My name is Michael Chachura, and I'm the other co-editor-in-chief of the Race and Law Review. We want to thank you all for joining us here today for the second day of our symposium. This past year has been a challenging year of racial reckoning, full of conversations about race.
So we wanted to use our symposium as a platform to address how law schools can better participate in these conversations. Specifically, in our 3 days, we will be discussing how to build an anti-racist law school and curriculum.
Please join us on Friday for panels that address admissions and retention and student organizations and activism.
The Race and the Law Review analyzes the intersection of race and the law, and we couldn't have chosen a more poignant topic to address. We hope to foster meaningful conversations here today and for the rest of the week.
And before we begin, we wanted to thank our faculty advisors, Dean Cuison-Villazonr, Professor Hawkins, who will be moderating this panel today, Professor Paradise, and Habiba Johnson. Thank you so much for helping us put on this symposium. Lastly, if you have any questions for the panelists, please use the Q&A function. Instead of raising your hand, the speakers will not be calling on participants with their hands raised. And we look forward to today's conversations. And so with that, thank you, Professor Hawkins.
Thank you, Michael and Monica. It is my privilege to moderate today's panel discussion on race in the curriculum as a part of this 3-day symposium on how to build an anti-racist curriculum and law school. I hope you guys joined us on Monday. It was an amazing panel with the deans, and we're going to continue that conversation today with a distinguished guest list of panelists. I will not belabor their biographies. Obviously, they are all really thoughtful people who have engaged around this issue. Professor Brant from Akron Law School. We have Professor Anthony Farley from Albany Law School, Professor Jennifer Wriggins from Maine School of Law, and then both Professors Wesley and Stacy Seicshnaydre from the Tulane Law School. Thank you all for joining us. Each of our panelists today has personal experience doing this work around race in the curriculum. And in addition to offering their thoughts here today, each will be contributing to our symposium edition of the journal. So after listening to our session, I encourage everyone when it is released to go to the symposium edition of the journal and read more about the work that each of these panelists have done that they will be publishing with our journal. But for today, what I'd like to do is to ask a series of questions that I'm going to direct to the panelists to hopefully generate a robust dialogue, raising some of what I hope are the key concerns we all have around this work. I want to encourage the audience to post questions using the Q&A feature throughout our session. I will be monitoring those questions, and if we have time at the end, I will certainly field some of those questions and direct them to the panelists, but to the extent that I am able, I will integrate them into our own discussion throughout. So with that, I'm going to get started by asking each of the panelists to speak to the ways in which you each have thought about and even constructed curriculum that involve anti-racist training. And we know that these models, the kind of proposals, vary widely from offering a single mandatory course either in the first year or in the upper level curriculum, or embedding it throughout the curriculum, right, in each of the kind of doctrinal courses that are part of the mandatory curriculum. Each of you, as I said, has done this work, has given considerable thought to how best to structure building anti-racism into the legal curriculum might kind of look. And so I want each of you to offer your thoughts and your experiences on the structures that you think work best, or the ones that you have the most experience implementing and how those have worked. I'm going to start with you, Professor Farley.
Oh, well, maybe I'll address this by starting to talking about the why of it, right? A brilliant classmate of mine when I was a first-year student created a series of cartoons to explain our entire curriculum to us by saying the railroad wins, because the railroad always wins. Like property, contracts, torts, con law 1, criminal law, and civil procedure are all presented to law students as Gilded Age jurisprudence, right? There is a dash of FDR reformism at the periphery, and fundamental change is left as everlastingly irrelevant. The off-topic neophyte interruption,
Sorry about that. Thank you so much. Professor Wriggins.
Thank you so much. It's wonderful to be here. So asking the race and racial subordination question in every course and changing course content depending on the result of that inquiry is my approach. And I think this is particularly important in the required first year courses. My focus is on torts and insurance, and I started this work 16 years ago when an African-American student in my torts class raised his hand and asked me how the tort system treated African-Americans' claims. And I said I didn't know, but would find out. And I looked at what had then been published in the legal literature and found there was almost nothing. And I delved in and found hundreds, if not thousands, of reported cases brought by African-Americans, starting from the end of slavery up until the 1950s. It was at that point that judges stopped identifying the race of parties and witnesses that they perceived as not being white. And so studying these cases, I've written a series of articles and co-written a book, and the article I'm writing for the symposium has some specific recommendations of cases and topics to include. And in torts, teachers and casebooks frequently reference history, change, and content. For example, we spend time in many torts cases thinking about collisions between autos and horse-drawn buggies beginning in 1920, to mention a classic case that probably everyone has read. And the history and context of race and racism in torts is obviously relevant and important as well. Torts is, after all, part of the legal system, which has been inseparable from racism. Most case books I have looked at have maybe one case that references race and maybe a small section on damages, but there's more, much more that can be done in the torts course. And I will, in the interest of time, just go quickly through a few major points and then a couple cases if there's time, and please interrupt me if there isn't. But so some basic background points. Torts has been a huge failure in many ways where African Americans were concerned. Very few cases were brought for lynching, for example, and other assaults and batteries related to racism. And acknowledging this is really important. But at the same time, African American tort system, starting right after slavery, despite racist exclusion from decision-making roles. The private enforcement system of torts made this access possible, and sometimes the railroad lost. African-American plaintiffs won many successes as well as experienced many losses. There was a race-based discount applied to their losses through many mechanisms in the tort system, and the unequal distribution of liability insurance by race is significant in torts in the ways it takes time to delve into. And now to quickly turn to some specifics. There are pedagogically interesting and useful reported cases, appellate cases that raise issues of race and racism in each doctrinal area that should be included in torts cases. Some cases have race, racism, and doctrine in the facts and the law of the case. And the negligence case of Bullock versus Tamiami Trail Tours is an example. It deals with negligence issues like duty, breach, and causation, and also directly deals with civil rights, showing how torts and negligence can have a civil rights aspect. The case is about whether a bus company should be liable for assault by a passenger of a couple sitting in the front of an interstate bus in Florida in 1956, shortly after interstate buses were ordered to be desegregated, where the wife seemed to be white and the husband seemed to be Black. The Fifth Circuit's decision in this case and the district courts should be part of the torts canon, in my opinion. And then intentional torts, there's various options. Sometimes there's a doctrinal issue that's maybe kind of dry, like the scope of agency, and the facts or some other aspect of the case deal with race and racism. A 1922 North Carolina Supreme Court case, Wilson versus Singer sewing machine, is an example. A Singer employee went to the home of an African-American woman who had a sewing machine on an installment contract. He grabbed the machine and threw her Bible on the floor. She suffered injury of a psychological nature from this, and she won in front of an all-white jury. The jury instructions in the court decision can be used to foreground issues related to race, racism, and the tort system. Third, and almost finally, the unequal distribution of liability insurance by race, which took place in part through insurance companies redlining neighborhoods inhabited by African Americans, affected what torts got brought. It affects what torts get compensated and what torts do not get compensated. If a tort took place in a redlined area, there would not be a tort brought. An example of this is the famous chair pulling case that probably people have read, where the 5-year-old kid was held liable for large damage when he pulled the chair out from a little old lady who was sitting down. That judgment was paid by his parents' homeowners insurance. And if they didn't have homeowners insurance, there wouldn't have been a tort case. The medical bills would have to be paid by the old woman, and she could have lost everything that she owned. So this is an unacknowledged backdrop that's in the background of torts, and it's important to keep thinking about it. Damages is an important additional area, and one I don't have time for. So these are just examples of cases and issues that I think can and should be included in the torts curriculum. And torts is an excellent place to do this work. I have slides and more further reading that I will give to the course organizers. Those are my preliminary thoughts. Thank you.
Thank you, Professor Wriggins. And now Professor Wesley is going to talk about the experience in doing this work on behalf of himself and Professor Seicshnaydre at Tulane Law School.
Thank you so much, Professor Hawkins. And I'd also like to begin by thanking the organizers of the symposium and giving us this opportunity to speak. I want to first address this duality that you used to frame your question between embedding anti-racist instruction throughout the curriculum, or what's may be referred to as a pervasive method, versus offering a mandatory course requirement, maybe in the first year, maybe as an upper level course. And perhaps the drawbacks of each, but maybe focusing on the pervasive method. I teach legal profession at Tulane as part of my course package, and I've been teaching it long enough to remember the proposal that was made by Deborah Rohde that legal ethics should be taught using the pervasive method. And I think that it never really took off at Tulane and perhaps at other law schools as well, in part because of the fear that that there would be a lot of gaps or inconsistency in how the message of legal ethics was put across by the various faculty members as they taught their courses. So also, I think that there was a fear of the trivialization of those legal ethics rules if they weren't organized in a coherent fashion and sort of given to students as a package. So whatever the reasons may have been, at Tulane at least, we've always sort of taught legal profession as a kind of capstone. And I really like the capstone approach because it draws on knowledge of other courses. I mean, what I was thinking about as I was listening to Professor Farley and Professor Wriggins was that there really is a kind of normative approach to the standard law school curriculum that, and at the same time, there are ways in which you can embed this anti-racist instruction in most of that curriculum, if not all of it. But again, I fear that taking a pervasive approach, a lot would fall through the cracks. Some faculty will simply just not do it. They would not feel comfortable doing it. They won't feel that they have the expertise to do it. And so it will not be delivered in a manner that's substantive and coherent for the students. I also want to compare my experience of teaching CRT, a critical race theory seminar, which I've also been doing for over 20 years at Tulane on a non-mandatory, as a non-mandatory upper level seminar with a required prerequisite in 14th Amendment. And what I've seen is that the interest in the seminar waxes and wanes depending on what's happening in the economy, to students' perceptions of what they think the course might be about and what they might discuss. It was very interesting, for instance, to me this past semester when Professor Seicshnaydre and I taught the anti-racism course as a kind of pop-up course in response to all of the social unrest on race that was happening in the country. And we felt our students really wanted a course like this. And that perception was correct. That course was very heavily subscribed at the same time that the critical race theory seminar had its very small number of students who seemed to be interested. So it was somewhat ironic for me at the time. And I do think that if the course is not mandatory and if there isn't a crisis that folks are responding to, there's a tendency towards ghettoization of a course like that. It's a tendency that to perceive it as lacking importance to professional interests and opportunities. And so, but I also believe that a mandatory requirement entails the necessity of including some sort of pragmatic and consequential approach to that course. And we can talk more about what that might be, perhaps inclusion of an MPRE or bar exam component. I also think that expertise is essential for anti-racism instruction, especially in a traditionally white institution like Tulane, to account for the reluctance of students to engage in public discussions of race and anti-racism.
And Professor Wesley, that's a very good point that I want to get to later. But first, I want to give Professor Brant Lee an opportunity to weigh in. So we've heard, incorporated as a, part of the doctrinal first year thinking like a lawyer, embedded in all courses, including things like torts where it might seem remote, compare it to a capstone, right, in the upper level that really is very thoughtful and draws on a lot of legal learning. Professor Lee, you have probably one of the most unique perspectives on how to do this work. You actually think law schools are uniquely situated to play a larger role in educating society at large and not just law students about the history of racial subordination in this country. Can you tell us about your experience doing that work?
Rookie mistake. So I just want to take you back to last summer, right? There has not in my lifetime been as much attention from the general public to critical perspectives on race as there was at the end of last summer. And in response to the moment, last fall, I taught a free online course to the public on racial equality in the law at the suggestion of my dean. And 5,000 people enrolled, right? Actually over 5,000, but we had to cut it off. And I just make the observation to start with that law schools and law faculty have a certain amount of credibility and respect in this area that I think other disciplines might not, right? We have an opening to participate in the broader sort of the long-term project of transforming the big narrative about race in America. And so what I want to talk about is the choices that had to be made, right? Because I had a professor of African-American history enrolled. I had judges. I had a white working class acquaintance who had been a fellow high school band parent, right? I had my mom, 87 years old in San Francisco, who was taking my class, my cousin, the hotel concierge, right? A probation department in New York did it as a group, right? A child services office in Columbus did the same thing. Like really a broad spectrum of people. 66% white, and actually even more, maybe more surprising, or I don't know if it's surprising, 87% women, people who signed up to take this course. So here's what was important. I'm going to talk about sort of introductory material, content, and themes. I'm going to try to do this quickly, right? First, as a matter of tone, I don't believe that people can learn when they're being defensive or they're being scolded, right? And so the material itself is harsh and hard enough, and my own demeanor was a welcoming and open one. I wanted to establish some premises right at the outset, right? That the Black-white narrative, in my view, is predominant, and we focus almost entirely on that. I had 12 hours, 12 weeks, 1-hour sessions, right? So not that much time to cover everything, right? Another premise I wanted to talk about right at the outset was why it is that race is so hard to talk about. Everyone feels simultaneously accused and self-justified. And emotionally, there can be kind of the symmetry, right? You feel like you're being accused of being racist. You feel like you're being accused of being inferior. But, whatever emotional symmetry there might be, the asymmetry is actually just numerical power, right? Just white democratic numerical power. White people have historically been able to fall back on most people agreeing with them, right? So most history books affirming them, they could elect the people they wanted to govern. Their ideas were made into policy. They did not have the same stake, right, in this argument. I mean, I had to acknowledge that this was happening even in this class, right? My class is 66% white. If I'm gonna, there's no way to talk to everyone sort of equally about subject matter that people bring so much difference to. And I wanted to at least recognize and make transparent that that was gonna happen even in this class, right? If I'm talking generally, most of my comments were at where I will admit, right, focused primarily on educating white people in ways that did not convey in exactly the same way to the Black people in the audience, but which I think was still learning or was appreciated. And I would say often, in the class, I'd say, well, most of the white people in the audience may have had this experience, or many of the Black people in the audience may already know, right, or may already know this. Let me just really quickly on content. Really important, I thought, to base it on history, right? Because historical fact can be reported in a way that feels objective, even if it's new history. And then to connect that history to present day inequality, right? Especially focusing on wealth, but also health and everything else, right? And then two themes, and we can come back to any of this, but two themes that I really decided to make the focus. One of them is just the tragedy of race and democracy, right? The history of who gets represented in Congress and what policies get made and how those either subtly or explicitly, right, enhanced racial privilege. And then connecting ideology to what racism cost all of us, right? The larger arc of the emerging story, I think, is that the turn away from government support, right, towards more individualistic conceptions of meritocracy coincides with the cementing of advantages of whiteness. But white people are not immune from the costs of this kind of individualism. And I think they know it. And I think the time is right to sort of call attention to that. So that's a mouthful, and I'll stop with that. But it was quite an experience, and one that I think that we're going to replicate.
Thank you, Professor Lee. And that's a wonderful segue, because you say the time is right. And Professor Wesley also mentioned timing, right? And why, he felt that there was a need to offer a mini course on this issue in this moment. I want to turn to that issue of timing, because more than 2 decades ago, in 2000, the Liaison Committee on Medical Education of the Association of the American Medical Colleges introduced the following standard for cultural competence in medical education. The faculty and students must demonstrate an understanding of the manner in which people of diverse cultures and belief systems perceive health and illness and respond to various symptoms, diseases, and treatments. Medical students should learn to recognize and appropriately address gender and cultural biases in healthcare delivery while considering first the health of the patient. This is the standard that was introduced more than 2 decades ago for instruction in medical education. Why has it taken the Legal Academy so long to begin to consider the imperative of this kind of cultural competence in legal education, and more importantly, to impose standards for legal education in this regard? Professor Seicshnaydre, I know that you've thought about this. Why don't you go ahead and start, since we haven't heard from you?
Really great to be with everyone today, and I really appreciate the students, organizing this panel and welcoming us today. It's difficult to imagine medical training without patients, but a majority of U.S. law schools did not even incorporate a live lawyer-client relationship into their curriculum until relatively recently, right? With the advent of clinical education happening, a few decades ago for most, longer ago for many others. But even now, legal education is lawyer-centered and doctrine-centered. Clinics are siloed. They're not required. They don't come till later. And as one of our students said in our mini course, the lived experience of the law for communities of color and impoverished communities is rarely discussed, if at all, in many law school classrooms. So if we're still centering lawyers and doctrine in the first 2 years rather than clients, we won't be interested in whether the law is written, interpreted, or applied to reinforce social or racial hierarchies. So clinical scholars and teachers have been thinking about these issues for decades, just like critical race theorists and other crits, and writing about it. There's a rich literature of clinical scholarship addressing the why and the when and the how to address identity and context in the law school curriculum, and making the case that lawyers need fluency in the way that identity of both the lawyer and the client will shape the counseling relationship and the legal system. And so even though every client's unique and comes in with their own life experience and interests and values, a client-centered education is going to be more likely to force students to confront the way that identity shapes a client's experiences and expectations, and the way that clients are experiencing legal doctrine and legal systems differently, depending on their identities. So the ABA has taken a step to crack open this door by adopting Standard 302. And as Stacy just mentioned, this is 2015. This is really recently cracking open the door, not to require consideration of culture, but to require learning outcomes that include competencies, not just in doctrine, that include competency in other things like analysis, problem solving, professional responsibility, and other professional skills. So if you look at 302, law schools can choose which other professional skills they want to include in their curriculum, and they include mention of cultural competency, right? So this is like a cracking open the door. And it's optional, right? It's not required like in the medical educational system. But I think this is a way that many law schools have already started, and that others can join to consider requiring considerations of identity in the first 2 years.
Thank you. But we know that if we begin to have this conversation about mandatory changes to the legal curriculum, we're going to get pushback And there are going to be a number of, I think, threads of opposition. And one is, they're already elective courses, and obviously all law schools don't have critical race theory in the upper level curriculum, but many do. And so they will say that's enough. Why do we have to impose a mandatory requirement? And Professor Seicshnaydre, you've already pointed to some of that in terms of the way we need to reorient legal education away from kind of lawyer-centric to client-centric. Why is it that we need to make sure that this is not left to some elective and kind of arbitrary exposure for students? And I want to add a dimension of the kind of concern that was raised by Professor Sarnoff in the comments in the question and answer, and that is, and if we're going to make it mandatory, what are we testing for, right? What specific skills are we trying to impart, and how do we measure that? So I'm going to start with Professor Farley again in terms of talking about why is it important that it be mandatory, not elective, and how do we structure this if we're going to make it mandatory to make it an efficient part of legal education?
I think we need to stop worrying about efficiency in the academy, right? We're an academy, not a knowledge factory, right? This is learning things, not learning things of importance, not just learning how to flip burgers, right? So the efficiency measurements are all ways of degrading the academy down to a particular ideology that they're trying to sell us. So look, virtually every law school in the country advertises itself as a significant step toward the Martin Luther King 1963, I have a dream ism, right? The 1963 future. The pictures in the law school's brochures multiply every word of text by 1,000. Law schools all present themselves as headed to or next to or adjacent to some kind of promised land. The critical race theory invites the legal academy to take that promise seriously. And that's why it really needs to be a mandatory course, an intervention in the rest of the Gilded Age jurisprudence that we force on students during the first year. MLK 1967-68, to pick a favorite of the legal academy, explained that his 1963 dream could only become reality by eliminating militarism, capitalism, and racism. You can't get rid of any one without getting rid of the other two. Poverty per 1968's MLK could be immediately eliminated. All of us per 1968 MLK needed to side with the barefoot people of the world rising up against American imperialism in Vietnam and other countries. That MLK gets forgotten. The first is woven into legal doctrine all the time. Critical race theory is a way of thinking about the doctrinal interference with Martin Luther King's dream, a promise we've all already made to ourselves, right, to achieve, right? We have a national holiday for it. It comes up all the time. Law schools advertise themselves with that kind of rhetoric. You can't make people teach things they don't want to teach, right? So if somebody isn't teaching the story of white racism in their course, be it property, contracts, torts, con law, ones, criminal law, or civil procedure, it's because they don't want to. And if you make them teach it, well, they're going to teach it in a way that's going to be surprising and won't be anti-racist at all. So I think that's one problem, right? We're not all, like, all law schools advertise themselves as an MLK dreamland, but few of them are an MLK dreamland. We have lots of people writing in the legal academy that are participating in mainstream jurisprudence, and mainstream jurisprudence is a story of the efficiency, rightness, fairness, justice, necessity, the forever, the kind of eternity of Black misery, right? From the beginning to the present, the Legal Academy has told a story of why it's great that Black people don't have things that everybody else gets. The Martin Luther King dreamism may be good for us because it may justify a course that takes King's dream seriously, not just the 1963 version, but the 1968 version. King 68 was a quota king. Rigid numerical guidelines should guide hiring in every institution. They should match the population in the area to the population of the employees, King wrote, and not just at the entry level, but at the top of the organizations. The organizations themselves had to be rethought so that, and in fact, even the legal system within which the organizations operate had to be rethought to make sure the folks on top weren't all one color, and to make sure the folks on top were working for the elimination, not just of racism, as we hear with this loose talk of inclusion, but the elimination of capitalism and the elimination of militarism.
So that's certainly true that the radical king does not get cited enough, right, for the way in which we should think about the law and, you know, the social change and society and justice more broadly. We do often think about the 1963 I Have a Dream King, but not enough about the radical king. Professor Wesley, I know that you've also thought about this question. Why make it mandatory? And you have a particular conception, right, of having it be capstone and really having it a robust part of lawyer skill building. So can you talk to this question about why we have to make it mandatory? And if you can respond also to Professor Sarnoff's, what are the skills specifically that you think, right, especially building on the kind of underclass or, you know, first year and second year, if it's going to be a capstone course, what does that skill development look like in a capstone course?
Well, I'm going to try to be brief. I think that Professor Seicshnaydre has already made the point about cultural competence. From my perspective as a teacher of legal ethics, cultural incompetence improves professionalism and ethical practice. Those are things that require us to take into account the demographics of the students that we admit into these institutions, many of whom have gone to segregated schools. Some of them may be first-time admittees to higher education or to professional school within their families. So each student's profile tells a different type of story, and from my perspective, building that cultural competence will improve everyone's professionalism as well as their ethical practice. I think also increasing diversity within our society means that the sorts of issues that get raised and skills developed in anti-racist instruction will become, if not already, as pervasive as professional opportunities that our students might pursue. So you really can't have a situation where you ignore a key component of what people will face as lawyers, scrubbed from the instruction they receive within law school. Already students complain that much of what they learn in law school has no practical application in their actual lives as practicing lawyers. This would be a clear exception to that. And I also think that it builds good citizenship, and good citizenship builds collegiality, and it builds commitment. There's a lot of unfinished business from the King era. We haven't done what King told us we needed to do in order to become the beloved community, and lawyers have a role. And so I think that's why I think this should be mandatory.
Thank you for that, Professor Wesley. Now, Professor Lee, to put a finer point on this, and I'm going to cite another question from the Q&A, because someone raises the fact that Professor Russell McLean at Maryland recently pointed out that the ABA Model Rule 8.4G, which for those of you who are not familiar, deals with preventing bias in the profession, in the practice, and prevents attorneys from engaging in any kind of harmful, derogatory, or demeaning speech, and says that that could serve as a springboard for a standard for legal education. However, we know with the backlash against implicit bias training, critical race theory under the Trump administration, there has been lots of pushback and challenges to that kind of framing. So for those who might not be familiar, recently Boise State University had to suspend 52 sections of a diversity course taught by 36 faculty and that enrolled 1,300 students because someone said they were, quote, made to feel humiliated and degraded in class for their beliefs and values. The Idaho State Legislature then went on to reduce the university's budget by $409,000, the exact amount the university said it spent on social justice programming. So we can understand that this pushback, right, might not just come from internal to the legal academy. It might come from external forces as well, who are bound and determined to really oppose the kind of introduction of this critical lens on our society. You've had a similar experience dealing with this kind of external pressure as well as the internal pressure, Professor Lee. Can you talk about that?
It's been a whole year, right? You would think I would know. You know, in response both to your question and to actually the previous question, it's really important to recognize that we are all in different institutions and in different geographical areas, and it really makes a difference, right? You know, your story was about Idaho. Ohio is the formerly purple, trending red state. You know, ours is a state university. Our board of trustees is appointed by the governor, who's been Republican for the last, you know, several terms. And so you're right, the context for each of us is a little bit different. You know, we are having this exact discussion in Akron about whether to do things mandatory. We have not had mandatory programming except for a short discussion by me at orientation, right? And then after last summer, there was some demands from student leaders. We were a little busy, but then incidents happened, right, this last semester, and the demands have blossomed. And it is all sort of being carried around, this discussion about what kind of programming we offer in a pretty public way. And so part of that discussion has been a response to this campaign against critical race theory. If you're not paying attention to this, right, there is a sort of intentional strategic targeting of critical race theory. They are finding examples from, I just saw one that somebody referred me to of a training that was posted on the Oregon Board of Education website that teaches that math, well, you know, they cherry pick sort of individual sentences, but the part that they don't like about this is that finding one right answer in math education is you know, white supremacist, and they find sentences like that to sort of make fun of, right, and highlight, and that's the kind of example they're using in Idaho, right, with the legislature to make CRT a scary thing. And we have had concerns, and you know, you said internally and thinking that the legislature was external. We've had concerns about this, sort of the impact of CRT on free speech, right? And scaring people and vilifying white students and making them afraid. We have had that criticism internally at the faculty level, internally from our students, as well as, right, what might come externally from sort of, you know, larger players. You know, I don't have an answer. I will tell you that one of the things I've been starting to do is to try to be the CRT whisperer, right? To translate those extreme statements that they find into sort of ordinary language. So, you know, there have been studies, and I think we can be familiar with this, right? That wealthy students are encouraged to be creative, and poor students, including poor white students, right, are taught that they have to get it right or else, right? And we have all experienced rigidity, right, from teachers who say there is only one way, you have to do it my way or it is wrong. And to explain that that math instruction example that they found is a response to that, right? A response to something that, an approach to how students learn that can be sort of more open to different learning styles, right? Is a different way of saying really the same thing, right? Which is, you know, maybe it's a little counterintuitive with math. And so I am finding out, I don't have answers. We are negotiating this exact question right now. And I am finding that that explanation of CRT is sort of ending up being central to how to respond to that kind of critique.
So Professor Wriggins, given what we know is the kind of pushback, given the difficulty of doing something on a larger scale, particularly perhaps organizing the legal academy to make this mandatory, what can law schools start to do in terms of structuring their curriculum to start to address this? What is an easy first step that people can take? What is the thing that people can tackle as a first matter, you think?
I think that professors need to start, asking the racism question regarding every course. And I think starting with the first year course is a good place to start. And it is a very path dependent field, right? As we've seen. And that can change, I think, through starting to really look for that question in different courses. And I'm hoping that it happens. It's happening somewhat in torts, and I wish it would happen more quickly, but adding it, in these mandatory courses, content, I think can be really helpful, and faculty really looking into that and to try and figure out what's missing in terms of race and racism and learn about it. I don't think it has to be all Gilded Age jurisprudence. I think we can make changes, and there's nothing preventing faculty from doing that. I mean, it's not like it's a physics course where we absolutely have to teach E equals MC squared, right? I mean, Paul's graph, going to the torts example again, it's a wonderful case, but we don't have to have all the curriculum be the same as it is, and we don't have to have as much attention on Paul's graph and things like that as we did. We can change the canon, and we should change the canon. And now, there was, as I mentioned, there wasn't scholarship in this area until like 15 years ago, which is a long time, but it's also not a long time. And really pushing publishers, pushing faculty, pushing each other, to make changes and look at it, I think is something that is a good first step. And it's a very practical step that can be done now.
Professor Wesley, you have any thoughts on what is it that we can do immediately? How can we start to tackle this in our curriculum if we want to start to shift to being more thoughtful and deliberative about introducing some anti-racist content in our curriculum?
Yes, one of the things that happened at Tulane in the wake of last year's social unrest on race was a top to bottom review of our existing offerings and practices. And I think that that's a first step towards building internal and then external consensus for change. In light of Professor Wriggins' point, I would feel more comfortable with pervasive teaching if we also had critical race CLEs for mandatory critical race CLEs for faculty. Because I don't necessarily want faculty who have no prior experience or knowledge on this topic to be teaching, giving anti-racist instruction. So I would want to see that as well. I would say, additionally, it's going to be necessary to hire. You have to hire people in to do these courses. One of the things that Professor Seicshnaydre and I struggled with our anti-racist lawyering course was we didn't have all the expertise that we needed to teach that course in-house. And so we had to rely on speakers from the outside, which was great to have those outsiders, but but it's not something that it facilitates something that's going to be offered on a regular basis. I also want to say that I did talk about earlier on a capstone approach, but I don't think that you can have just one course. I really think that the capstone is one thing, but then you also should have something in the first year for students just as they come in, so that it's not something that you sort of give what we've been calling the Gilded Age curriculum, and then at the very end, oh yeah, here's race. I think that also sort of trivializes this type of instruction. And finally, I would, well, two other things, but I'll just confine myself to one. And this may sound counterintuitive, but I would say don't wait for a crisis to happen. But if and when crisis does happen, don't be timid, right? I mean, you really have to sort of grasp the bull by the horns and really take this on, because you know, one of the things about law schools as institutions is that students come and go. They don't stay, and so that's a primary constituency that's demanding change at this moment. So if you have an administration that's serious about incorporating anti-racist instruction, seize the moment while you can.
Seize the moment, great advice, but you raised another critical concern that I know Professor Seicshnaydre wants to talk about, and that is, how do we staff these classes? How do we make sure that we're covering this content if we don't necessarily have all of the faculty who are trained, who are competent, who are knowledgeable to do that? And I want to add a comment from Professor Wendy Green in the Q&A. What are your thoughts about inquiring about this commitment to doing this work as a part of new faculty hiring? Is that a way to make sure that prospectively, at least, you are developing the internal capacity to staff this coursework?
Yes, I know some law schools are actually incorporating questions about equity experience and their, candidates' capacities to address equity and their history of addressing equity as part of the evaluation of candidates. So I think law schools can absolutely center that. Just to kind of answer the question about how you bring in the expertise that's needed, one of the things that I really enjoyed about collaborating with Robert is, he's my crit mentor, and I'm bringing more of a clinical education background and a civil rights practice and fair housing background. And so just melding that theory and practice was, I thought, so valuable. And we tried to model that or sort of carry that into our course. And so every week we had academics, we had practitioners, but the missing piece was organizers. And one thing that we recognized really early on was that we needed to bring in voices that were closest to the harm we were discussing. And that part of training students, not just to be anti-racist students, but anti-racist lawyers, was that they needed to listen to the voices that were the closest to the harm. And so when we didn't always succeed at that, our students held us accountable, and that was wonderful. So when they evaluated us at the end, they said, you kept telling us to listen to communities and to voices closest to the harm. We needed to hear more of those voices. And so just to kind of share, and also to just credit all of the different colleagues that we relied on. Sort of, Robert mentioned, the challenge is covering the breadth of subject matter required us to go beyond just our own expertise. We had to tap into our networks. We had to tap into our colleagues' networks. Professor Saru Matambanazzo, Professor Jancy Hofel, every single clinic director helped us build our reading, our syllabus, and build the networks of folks who came in. I just want to share a quote from a student, kind of on this point of bringing in organizers and community voices. For a long time, I thought it was my job to give a voice to the voiceless. Instead, my job is to fight the system that keeps them from being heard. And that is the most important thing I learned in this class. So I think that really sort of underscores how an anti-racist curriculum really does need to kind of, sure, lawyers are important and lawyers have expertise, but communities have real genius and real expertise, and those voices need to be brought in as well. I think the issue is sustainability and budget, as Robert mentioned, budget in that, you know, academics get paid to talk about their scholarship, but community organizers aren't necessarily getting paid to share their expertise. And so if we're going to do this in the future, we need to find a way to build a budget to pay people to come in and teach our students and not just to expect them to do it for free.
Thank you for that. Final question, and this comes from the audience. I think it's a good one. And if you can answer it in about 30 seconds, because we only have about 2 minutes left for the panel. Can you give a question that anyone could apply to their own subject matter to better identify the race issues embedded within? That is, what one question do you think any professor could ask in the context of the courses that they teach to prompt dialogue about interrogating race and the way in which the law structures race and racism? Who wants to start? Should we start? Professor Farley, should we start back with you?
Oh, well, we could. I would turn the question around and I would say in maybe a three-part way. Are there race crits on your faculty? If not, why not, right? Are they hiring race crits for your faculty if they don't have any? And are tenured people of color involved in that selection process? And if not, why not? Are there diversity and inclusion people being offered to you as solutions to the George Floyd angst? If so, were those diversity and inclusion people given tenure, which they need to do their jobs properly, or were they hired at least with the input from the race crits on the faculty? Right. So I guess that my answer is to reframe that question and ask, where are the race crits, the tenured race crits on your faculty?
Thank you. Great question. Anybody have any advice for this person who wants to know, what is the one question that I could offer my students to be able to interrogate race in the law as it shows up in any subject matter? Anyone have a good question?
What role, I think Professor Lee was going to respond as well. What role does the plaintiff's race play in this case outcome? What role does the defendant's race play?
Great. Professor Lee, you have the last word in 30 seconds.
So I'm going to make 2 points in those 30 seconds. My question would be, what were the racial dynamics in society at the time that the principal tenet, the principal cases in your field were decided, right? What was going on? And I think that will lead to a lot of interesting, or could lead to a lot of interesting discussion. And the second point is, just to respond to some of this, it's implicit in what people are saying that you have to do hiring, that the people who are doing this work are few. And at some schools, we're really tired. And sort of to turn to the fact that we cannot do it all, right? That's why we need the hiring. So I know that many of you on this panel, right, have been doing a lot of extra work in this last year, that now that race has become so salient, right? And suddenly everybody wants to talk about it. Like, who's going to do that teaching for our students? And it comes down to a few faculty members who have enough to do.
Well, that is our time. And I want to thank all of our panelists so very much for sharing their experience and their words of wisdom. I want to now turn it over to the next panel and encourage everyone, when the symposium edition comes out, to go and read their papers, giving much more deep and full explanation of the work that they're doing in their institutions. Thank you all so much.
Thank you.
Thank you.